Hello, I'm Brad Green, and I'm an attorney with King and Green in Birmingham. There's been a lot of news about a decision of the Alabama Supreme Court that was released in February of this year dealing with whether or not Alabama's wrongful death of a minor act applies to frozen embryos that are being held in cold storage for people that are seeking in vitro fertilization treatment, IVF treatment. And the decision from the Alabama Supreme Court has been oftentimes wrongly reported as a 8-1 decision. It in fact was not an 8-1 decision. The majority opinion of the court was written by Justice J. Mitchell, and it was joined fully by two other justices. The Chief Justice wrote a concurring opinion in which he joined fully in the decision reached by the majority opinion, but it contained a lot of references that have been highlighted in the news reports. These references are both legal and religious, but they take a much more expansive view than the majority opinion did. There was also a concurrence by Justice Greg Shaw that said that he joined fully in the decision of the main opinion. So I believe certainly that there are 5 members of the court and perhaps 6 that certainly join fully with the rationale of the majority opinion. There was one full dissent written by Justice Greg Cook that has often been cited in these news reports. There's also a very important opinion that is a concurring opinion in the result by Justice Mendham, and a opinion that dissents in part and concurs in part by Justice Will Sellers that I think are awfully important as well to understand that the breakdown on the court was perhaps closer to a 6-3 decision than an 8-1 decision. Now, it doesn't matter as long as there's a majority on the court. That's the law in the state of Alabama right now. But I say that to explain a little bit more about how our Supreme Court works, and because the language in these concurring opinions sometimes can be very important in determining what comes next. And in the news right now, national news in fact, there is a great emphasis that the Alabama legislature, which is in session right now, that there have been bills introduced to fix a problem that has come about after the result of the release of this opinion on February 16th, and that is the largest provider of IVF treatment in the state of Alabama, which is UAB Hospital, has paused IVF treatments, and I believe 2 other smaller and perhaps more IVF treatment centers have paused or stopped treatment, and a company that provides transportation services of the frozen embryos, potentially that would be a company that's used to transfer these frozen embryos in Alabama out of state to another facility that won't be covered by this decision of the Supreme Court, has stopped transporting embryos. So everything is kind of held in place right now. One thing I would say about the bills introduced in the legislature, those are statutes, not constitutional amendments. And if you read the majority opinion as well as the concurrences by the Chief Justice and Justice Shaw, I think that it raises the possibility that a statute, which can be passed by a simple majority in the legislature, even if you could get that passed, I don't know that that would stand up under challenge, because the rationale cited by certainly a majority of the court is that earlier this decade, the people of Alabama adopted a constitutional amendment that is commonly referred to as a personhood amendment. In a lot of states, maybe not a lot, but a fair number of states over the years adopted these personhood amendments that were designed to come into force in the event that Roe versus Wade was overturned, which it was by the Dobbs decision. And so now these personhood amendments are being cited to say that a frozen embryo that has not yet been implanted into a woman's uterus through IVF treatment for someone to be able to have a child that otherwise wouldn't be able to have that child, that those frozen embryos that are usually donated, or as I understand it, sometimes discarded or destroyed, that they, under the constitutional amendment that was adopted by the voters, I believe in 2018, that they are considered persons. And that all manner of laws, both civil and criminal, could apply to that. Now, there's a lot of discussion in the various opinions. It's 131 pages. I encourage everyone to read it all. Read the majority opinion and read all the concurrences and the dissents. It is very important to understand that. I think a lot of the reporting out there about the fact that the legislature is going to do something, a bill might not be able to solve this issue as it relates to the Alabama Supreme Court's interpretation of the Personhood Amendment and how it applies to Alabama's Wrongful Death of a Minor Act. That Wrongful Death of a Minor Act has basically remained unchanged in our laws since about 1870, and there's a lot of discussion by the Supreme Court in the opinions and concurrences and dissents about that. There's a lot of stuff in there about English common law and how non-viable embryos under English common law certainly would not have been considered persons for criminal or civil liability. But there have been statutory changes, and there has been this personhood amendment that has been adopted as part of the Constitution of Alabama. So I don't think there is a quick fix. The Attorney General of the state of Alabama came out yesterday and said he has no intention of prosecuting doctors who discarded or destroy these embryos based on the wishes of the patients whose embryos those are. That is all determined, as I understand it, by contractual arrangements between the parents seeking the IVF treatment in the reproductive facility that they're using. The Attorney General says that he has no intention of doing that. One point that might be obvious is Attorney Generals are term limited in Alabama, and a new Attorney General might take a different view. Certainly, if the legislature passes some civil liability act that says the Alabama Wrongful Death of Minors Act does not apply to frozen embryos, someone may challenge that, and the Alabama Supreme Court may say, no, under the Constitution, under the Personhood Amendment that was adopted, they do. And that would require the legislature to pass a constitutional amendment and the voters to approve it. And that process takes a great deal of time. And the earliest something like that could happen would be this November. There's things moving in the Alabama legislature right now to put a constitutional amendment on the ballot in November, so you could obviously do it that quick. However, one thing I'll point out is some of the rules in the legislature. The law in Alabama says the legislature can't take up any other legislation before it passes the general fund and the education budget. And those almost always take almost the end of the session, which has to end in 100 calendar days and 30 legislative days. And we're already into the session, and those clocks are ticking. The legislature, by a supermajority, could pass what's called a budget isolation resolution, a BIR, that allows them to take up legislation early and pass it before they pass the budgets. But again, that's usually done for non-controversial items. I will note that there's already lawyers in the state who do a lot of litigation involving issues of reproductive rights, abortion rights. I think they would refer to themselves as very conservative folks that do a lot of work in the legislature and in litigation before the Supreme Court. And one of those individuals, who's very well known to the members of the Alabama Supreme Court, has stated exactly what I'm pointing out, that under the Personhood Amendment, a simple statute might not be the fix. I do think it's fair to say that there are very difficult decisions that come before our courts every day, and this is one of them. And when a court makes a decision, it seldom will be saw as perfect by anyone, including the justices that write it or the judges in certain cases that make those decisions. And so this is an example of how the law is imperfect in dealing with very, very serious issues, and how decisions from our court can have consequences down the line that members of the public can be surprised by. In fact, members of the bar and perhaps even members of the court itself can be surprised by the effects of their decision. So I hope this helps shed a little bit of light on what's going on, because it's not all that common that you see rulings like this that cause a great deal of fear and concern among parents who are seeking IVF treatment. Polls in Alabama and elsewhere show that the idea of in vitro fertilization is wildly popular across all demographic patterns, that people want folks to have the opportunity to have children. And the way this process works, as it's been explained in the decision by the Supreme Court, by analyzing the record before them, they point out that oftentimes you have to create multiple embryos to get a successful implantation inside a uterus that will grow into a baby and be born. And so it's what is the answer to a situation where, to be successful generally in doing this, you have to create more embryos than you perhaps need, and then you have to freeze those, and you have to maintain them in these specialized facilities. That is costly. And so what happens when there is some type of decision to discard or destroy those embryos, or to donate them, I might add? I think this decision raises a lot of issues about that. And then what happens when there's some type of accident or incident? In this particular case at the Mobile Infirmary Medical Center, a patient somehow gained access to the room where the freezers that these embryos were kept, and was able to pull them out of the freezer and drop them, in which, when they were outside the freezer and of course maybe made contact with the floor, that destroyed those embryos. There's nobody on the court that thinks that hospital is not liable in some ways. But for the Wrongful Death of a Minor Act in Alabama, wrongful death is all punitive damages, not compensatory. All punitive damages. And I think Justice Sellers, in his opinion, concurring in part, dissenting in part, points out that he believes this case is all about creating a way to obtain punitive damages that didn't otherwise exist in Alabama. There's some other references in the dissent from Justice Cook and the concurring opinion by Justice Mendham that also kind of speak to that. And I think it's important also to understand the outcomes here also deal with other issues in Alabama, where we are one of the states that only allows punitive damages for wrongful death, not compensatory damages. And so there are a lot of issues here about whether or not you get to punitive damages, you have to have a wrongful death, or you have to show that there was a intentional action on behalf of the defendant, in this case, we'll just call it the hospital, but the Center for Reproductive Medicine and Mobile Infirmary. I think those are together. Basically, it's a company that has a relationship with Mobile Infirmary Hospital, or Mobile Infirmary Medical Center. I think it's a more appropriate way to say it. There's certainly probably some liability that they have there, but the question is, you don't get to wrongful death and punitive damages probably in this particular situation without a finding that the frozen embryos are persons. And so I hope that helps explain it a little bit. Again, this video is not taking positions on anything other than this is a major legal issue in the state of Alabama. Our firm handles a lot of family law issues, and I can tell you that there will be family law issues regarding custody if frozen embryos are considered children, and the parents who contracted with a reproductive service facility to have those embryos created and then frozen and kept in storage, if those parents later are no longer together, there can be issues with custody that come up over those embryos based on this decision. So I think it's really important, and it's going to have a lot of downstream effects. And I think that whatever the legislature might do in terms of statutes may well be challenged, and this could be an ongoing legal back and forth for potentially months or a few years until it's resolved one way or the other. I hope this was instructive, and again, we try to talk about things that are important to people, not just in Alabama but elsewhere, but specifically here in Alabama, and so I thank you for watching.